Welcome to another episode of Hard Lessons with Demel Hannah. I'm your host, Demel Hannah. Today, we're going to be talking about detainment, charges, trial, and conviction, because that's a sequential order that it goes in. And I want to talk to you guys about that. These four particular realities, excuse me, because last week, the last episode, I talked to you guys about knowing your rights in prison. So let's talk about probable cause. If you see me in an area and it was just a crime that took place, and the crime was alleged to have been perpetrated by a black male, just because you see me, that ain't probable cause to pull me over. That's not probable cause. But they'll use that as probable cause to pull me over. Well, it was just a robbery took place, in this particular area, and you know what I mean? It was a black male. You meet the description. Me and a million other people, that's not probable cause. But we see it all the time. They pull people over and they use that broad spectrum as probable cause to, harass you. So they just need evidence. Some evidence to come detain your ass. Legally, they supposed to render an indictment, but they do that second. They bogus. They do everything backwards. They supposed to render an indictment. An indictment gives them permission, validation to come get your ass. But based off hearsay, they can come get you. And they let the courts deal with all the legal stuff because they know the courts is going to back their ass up. So you've been detained. You're detained, right? They was bogus in my case. They use people that really didn't even know nothing really about the case. They indicted me on some gang stuff to secure, like murder detainment. They was bogus. Like they was so bogus. And this why it is imperative to know your rights, because when I learned my rights and I learned the Constitution in its entirety, not the stuff that they teach us in grammar school, like really learning the Constitution, when I really dissect that document and I immerse myself in the law library and got to reading those federal and northeastern law books, my indictment was bogus. When I asked the courts to send me a copy of my indictment, it was bogus. Like the statutes in which I was indicted under was bogus. Even if it's a murder case, there's different statutes. Like there's different statutes. Like first-degree murder isn't the same as intentional murder. Intentional murder isn't the same as felony murder. Felony murder isn't the same as conspiracy to commit murder. So, you got to really dissect this stuff, man. That's why I told you shouldn't even join the gang, man. But now that you've joined one and your ass is in the penitentiary, it's up to you. You go fight to get back out, or you just go die. Now, everybody that's in the penitentiary isn't guilty, you know, but those that are guilty, you know, you still can fight to get out or try to fight to lessen, you know, your sentence. So, man, when I started really fighting, I'm like, man, my indictment is bogus. Now, detainment, indictment, charges, conviction. Detainment, charges, the indictment is associated in the charges. Trial, conviction. So, you know, leading up to your trial, you going through, let me see. It's a mini trial that happens before your trial. Like for instance, let's say you had a hearing for motion to suppress statement. Now, a hearing for motion to suppress statement is basically they say you made a statement under interrogation, and you say you made that statement under duress. You know, your will was overborne, whether they physically assaulted you or mentally took you through some type of twilight zone, whereas you were so mentally drained, you just signed a piece of paper before you because you was under the opinion that if you signed that piece of paper, they would release you. You know, so your lawyer have put in a motion to suppress that statement. They trying to throw the statement out. So that's like a mini trial. If that statement is indeed thrown out, the case is thrown out. It could be a murder case. If you made a statement under interrogation and your attorney wasn't present, your parent wasn't present and you're a juvenile, or you said on the statement that you weren't comfortable or you was under drug influence, that statement could be thrown out. You dig? It could be rendered inadmissible. And when the judge throws the statement out, the case is thrown out. The case no longer exists because the case was built upon that statement. The whole case the statement is the nucleus of the case. So if there's no statement, there's no case. So it's imperative that you know your stuff. You know, detainment, charges, trial. If you are able to get certain things thrown out leading up to trial, eventually you will get the case thrown out and there won't be no trial. Now let's say you got to go to a trial. My trial consisted of 14 jurors. 2 of those are alternates. They stay on the jury panel until the jury goes back there for deliberation. If the jury, like for instance, if two of the main jurors can't stay throughout the duration of the whole process leading up to them going into deliberation, those 2 alternates will take the place of the 2 jurors that can't, stay, because people got lives, man. That's why the courts pay them, but they don't pay them nothing. They pay them a couple dollars, but people got lives. That's why this jury poll is it's important. It's important, and when you guys out there are commissioned to come, to jury duty, go, man. Go to jury duty, please. Especially if you have common sense. Go to jury duty, please. But yeah, so, if you have to pick a jury, the state's attorney, prosecutors are so shrewd when they picking juries. So shrewd. If you are a black person or if you are of minority, black, brown, poor, the prosecution is trying to keep as many people off the jury that looks like you. I had 3 people that look like me out of 14. Let that sink in. I had 3 people that looked like me out of 14. So, that's not a jury of my peers, but what can I do? So the prosecution is real shrewd. They got something called perimetry strikes. Y'all Google this. Now, the perimetry strikes is how the prosecution eliminates certain individuals that they think will favor the defendant on trial. So they use their perimetry strikes to remove those people that they think won't be good for them, but will be good or favor the defendant. Yep, it's a case called Batson versus Kentucky, whereas the prosecutor abused its perimetry strikes and used them. He was using them specifically against minority potential jurors, and he was, making sure they didn't land on the jury. And they shrewd, man. They shrewd, man. This is why the prisons are packed with individuals that look like me and that look like Gonzalez and that look like Jacob, the white Jacob that's poor out of, that probably come from poor environments. The poor fills up the prisons in America. Black and white, poor white, poor brown. Fills up prisons in America. So they have been able to shrewdly craft a jury that is going to favor them and not you. And now your ass have been convicted. So conviction, you go before the judge. They ask you, do you have any last words? Before sentencing, you say what you're going to say, whether you're going to apologize to the victim's family or apologize to your family for being a F up. You know what I mean? And, you go to prison, so detainment, charges, trial, conviction. You're detained on suspicion or probable cause, or they render an indictment. You're charged formally before you go before the chief judge. I don't know. You could pick a speedy trial. I don't know how long it varies. It varies. Some guys go to trial in 4 months. Some go in 4 years. It varies. So, you're either going to pick a jury based off how you've been interacting with your judge and how that relationship has blossomed throughout the process of you being detained. You're going to win or you're going to lose. If you lose, you could be sentenced and, sent on your merry way to whatever state institution or federal institution you're going to go to within a month or maybe 6 months or maybe a year. I don't know. It varies. It differs. But detainment is just that. Detainment. You wait until, they either say we don't have enough evidence, we'll get them next time, or you go to trial, but during the detainment process, charges are formally rendered, and then trial or not trial, whether it's a bench trial, the judge decide. Jury trial, jurors are your peers, might be your neighbors, but it's 14 in total in a criminal case, In a civil case, I believe it's 8 and 2 alternates. Yep. So detainment, charges, trial, conviction. It's serious, man. This ain't no joke. This is what you chose to do, though, with your life. So come on, join us. You know, Latino bunked or black. You might see a white, but he probably associated with the black organization or the Latino organization. So